is a root problem. He doesn't make any argument that anything in the deposition is sensitive or private in nature. In other words, he doesn't really make any real arguments as to why this entire deposition should be treated as confidential.
Zilla is not a criminal. I called him. I apologized.
So there's a fresh update in the Logan Paul defamation lawsuit against CoffeeZilla, and things just got way more complicated fast. It seriously looks like Logan and his legal team are trying to shape the story in court in a way that doesn't fully line up, and people are noticing. If you haven't been following closely, the recent moves aren't exactly helping Logan's side, and the pressure keeps building. Over the past few weeks, Logan and his attorneys have been pushing hard to keep his deposition out of the public eye, and that alone has set off a lot of side-eye online, because when someone fights this hard to keep something sealed, it makes everyone wonder what's actually in it. If you're not sure what a deposition is, here's the simple version. It's when CoffeeZilla's lawyers sit across from Logan and ask direct questions under oath on the record about the crypto projects and business decisions that sparked this whole situation. It's serious, it's recorded, and what's said can matter later in court. So yeah, people are asking the obvious question: why is Logan pushing so hard to keep that footage locked up? The most common assumption is that the questioning didn't go smoothly and that the answers might not look great if the public ever sees them. And here's the key part: can Logan just hide a deposition because it could make him look bad? Not really. Depositions are a normal part of lawsuits unless there's real sensitive private info involved, and courts usually lean toward transparency. In the latest update, Logan reportedly gave 4 reasons for wanting the deposition sealed. The first one was basically that CoffeeZilla can't be trusted with it, and that if it isn't sealed, CoffeeZilla could release it publicly, share it with other attorneys, or even pass it to investigators. The issue with Logan's first argument is pretty straightforward. None of what he described is actually against the law. If someone legally obtains information during litigation.
Here we're talking about how I think that in Logan Paul's reply, his lawyers did some things that can potentially backfire. And explaining this really starts with the weakness of his arguments. Let me put it this way. There's this old trial lawyer's saying that if you're weak on the facts but strong on the law, pound the law. If you're weak on the law but strong on the facts, pound the facts. And if you're weak on both, pound the table. Pounding the table is often thought of as being like
sharing it with proper authorities isn't some wild violation. That's often how formal reviews move forward. Logan's second claim was that CoffeeZilla has allegedly shared case material with federal authorities, and because of that, the deposition should stay confidential. But here's where that reasoning starts to wobble. There's no rule saying lawfully obtained evidence can't be provided to law enforcement. That's not misconduct. That's part of how systems function when questions need answers. Instead of cooling things down, these arguments seem to be drawing even more attention to the case. And when legal reasoning feels stretched, people notice. Now we get to Logan's third point, and this one centers around a protective order. He argued that there's already an order in place, and that CoffeeZilla is somehow violating the spirit of it by sharing information outside the lawsuit. But here's the problem. Protective orders apply to specific confidential materials. They don't automatically cover everything discussed in a case. If the material being shared isn't labeled confidential under that order, then claiming someone broke its spirit sounds more like a creative interpretation than a clear legal violation. Courts deal with exact wording, not vibes. Then came Logan's fourth argument. He suggested that CoffeeZilla was improperly sharing information with attorneys connected to the CryptoZoo class action lawsuit. He framed it as something questionable happening behind the scenes. But CoffeeZilla's legal team responded quickly, pointing out that non-confidential discovery can absolutely be shared with lawyers in related cases. That's standard practice when lawsuits overlap. Coordination between legal teams isn't automatically scandalous,
forceful, or aggressive in your tactics. But I actually like to think of it as any strategy to try to essentially distract from the fact that there really isn't much to your case or your position in this particular argument. But the thing is, depending on your strategy here, you could find yourself in the danger zone with the judge. And I think that is where we just might be in this particular issue. To start, Logan Paul's reply is an opportunity to strengthen the arguments from his original motion. It's supposed to be pretty limited in that it's supposed to be responding to to the opposition, but nevertheless, it should be able to use something to kind of bolster it somewhat. But instead of doing that, he basically repeats all of the arguments from his original motion, all of which, like I said, I think are already pretty weak. Now, to make matters worse for Paul, his lawyers at one point in this reply tried to do that thing that I described earlier. We're both.
When you line up all four of Logan's arguments, a pattern starts to show. None of them clearly identify a broken rule. None of them demonstrate obvious misconduct. They mostly challenge actions that appear to fall within normal legal boundaries. That's why many legal observers believe this effort to seal the deposition may not land the way Logan hopes. There's also been plenty of dramatic back and forth in court filings, but from what legal commentators have explained, Logan's team hasn't introduced major new facts that strongly justify sealing the deposition. Instead, the filings read more like procedural maneuvering, lots of paperwork, lots of technical arguments, not a lot of fresh substance. Zooming out, the bigger picture is hard to ignore. Logan is clearly pushing hard to keep that deposition sealed, and when someone fights this aggressively to block public access, it naturally raises questions. If the deposition clearly supported his side, would there be this level of resistance? At this stage, it feels less like a decisive legal victory and more like a strategy to slow the process down. Logan has significant financial resources. That means he can file motions.
Both sides will take the legal authority that the other side is using to support their arguments and try to show how it actually supports our side. But the problem is, as much as Paul's lawyers are trying to do that, in my opinion, I think they're very unsuccessful at it. For example, in this part of the reply, they're responding to CoffeeZilla's argument that in order to mark his deposition as confidential, Paul needs to show good cause. And this basically means that Logan Paul needs to have a good, rational reason that has something to do with some kind of privacy interest. It's really not all that hard to do, but the problem for Logan Paul is that nowhere in any of these filings does he ever argue that he has good cause for making any part of his deposition.
Respond to counter motions and extend timelines. Meanwhile, the core issue at the heart of this lawsuit hasn't been fully addressed in public view. That central question revolves around whether his public statements and actions surrounding CryptoZoo were misleading. Instead of confronting that issue directly, the focus has shifted toward procedural disputes. Should the deposition be sealed? Can discovery be shared? Did someone violate the spirit of a protective order? These side battles don't resolve the main controversy, but they do accomplish something else. They stretch out the timeline. Every new motion requires a response. That means more preparation, more filings, and more legal costs on both sides. In civil litigation, prolonged procedural fights can become a test of endurance. And when one party has deeper pockets, delay itself can become a strategic tool. Courts are familiar with these dynamics. Judges understand that sealing records is not a casual decision. The legal standard is high. A judge doesn't block public access simply because one side claims it might look bad. There has to be a clear, specific, evidence-based reason. Typically, courts only seal materials when they contain truly sensitive information. That might include detailed private medical records, specific financial account numbers, or protected information involving minors. Outside of those categories,
Paul tries to suggest that the case law CoffeeZilla is citing to says it's actually a more lenient standard than what CoffeeZilla is arguing. Specifically, Paul says defendants' own authorities recognize that the standard for designating non-filed materials as confidential is, quote unquote, more lenient. And then Paul cites to this case from the Fifth Circuit, Hoa Lee v. Exeter Financial Corporation. But the thing is, although Paul says that there's like this more lenient standard, he doesn't exactly say what that more lenient standard actually is. And there's a very good reason for that. That's because if he did, it would not.
Transparency is usually the default. So as this case continues, the fight over the deposition has become its own storyline. But until the court rules definitively, the bigger legal question still hangs in the air. And no amount of procedural back and forth can fully distract from that. Even in situations where sensitive material is involved, judges usually prefer narrow redactions. That means blocking out a specific sentence, a name, or a short section, not locking away an entire deposition from public view. And that's exactly where Logan's request starts running into serious resistance. You can't seal a full deposition just because it might be uncomfortable or potentially damaging to your public image. In court, arguments need precision. Judges expect exact page numbers, exact lines, and clear explanations for why each specific portion qualifies as confidential under the law. Saying this could hurt my reputation simply doesn't meet that standard. That sounds more like reputation management than legal necessity. In civil court, transparency is the default setting. The system is designed to serve the public interest, not to shield high-profile defendants from scrutiny. Unless there is a clear and compelling reason to restrict access, judicial records are meant to stay open. That principle is foundational. It's not optional. What makes this even more interesting is the legal precedent Logan's team chose to rely on. They cited a prior ruling in an effort to argue that the judge should allow more flexibility when sealing records.
Actually highlight the fact that the one thing that the Fifth Circuit says that Logan Paul needs in order to mark the deposition as confidential is good cause. Specifically, here's exactly what the Fifth Circuit says. In our view, courts should be ungenerous with their discretion to seal judicial records, which plays out in two legal standards relevant here. The first standard, requiring only good cause, applies to protective orders sealing documents produced in discovery. And then it goes on and actually says, under both standards, the working presumption is that judicial records should not be sealed. So reading that, the Fifth Circuit is actually pretty clear that Logan Paul's motion should
But when you actually examine the language from the Fifth Circuit, the support isn't as strong as it might first appear. The appeals court explained that one standard, good cause, applies to protective orders during the discovery phase. However, once a document becomes part of the judicial record and is officially filed, a stricter balancing test kicks in. And here's the key detail. Under both standards, the presumption favors openness. That means the starting point is transparency. Sealing is the exception, not the rule. Logan can't simply argue that the deposition is inconvenient or could cause reputational harm. He must show specific evidence-backed reasons that justify secrecy. Without that, the document generally remains accessible. It's difficult to ignore that the very case his team cited appears to reinforce the importance of public access. The Fifth Circuit made it clear that courts should be cautious when restricting transparency. That context matters. Throughout this dispute, Logan's filings have yet to present a sharply defined, legally compelling reason for sealing the entire deposition. The arguments raised so far have not clearly met the required threshold, and that's significant. Another factor that stands out is the level of resources involved. Logan has access to experienced legal counsel and the financial capacity to pursue extensive litigation strategies. Yet despite those resources, the arguments being presented appear to repeat.
Is this understanding of this issue pretty common across the board in the United States? But the Fifth Circuit is also binding authority on the court that we're in right now with this lawsuit. In other words, the judge in this case is required to follow this case law. And I want to share a little bit more from this Fifth Circuit opinion because I think it beautifully illustrates why it's important for the public, you and me, to have access to this kind of information. For context, this case, Hoali v. Exeter Financial Corporation, involved two parties who basically agreed behind closed doors to keep like 3/4 of the discovery in that case marked confidential, and then to seal it permanently just so that the public could never have access to it after the litigation was over. And by all appearances, they didn't do this because
positions that courts often scrutinize closely. That has led some legal observers to wonder whether the focus is on ultimately winning the motion to seal or simply extending the procedural timeline. At its core, this debate goes beyond one individual. Public court records exist to maintain accountability. If documents could be sealed whenever a powerful figure felt uncomfortable, transparency would become selective. The legal framework is structured specifically to prevent wealth or status from automatically granting special privacy in civil disputes. That's why the presumption favors openness in the first place. This principle also connects directly to the broader controversies surrounding CryptoZoo and the Pokemon-themed digital marketplace situation that has drawn regulatory attention. These are not small private disagreements between two unknown parties. These projects involve significant sums of money, large online audiences, and supporters who say they were financially affected. When a public figure launches a business venture through a massive platform and devoted fan base, and that venture later faces collapse or legal scrutiny, it shifts from private conflict to public concern. In the CryptoZoo matter, many participants stated they experienced financial losses after assurances of fixes and refunds were discussed
because this information was actually sensitive in any way. It's just that the parties wanted to keep information private amongst themselves. And so the Fifth Circuit said in response to this, the public deserves better. The presumption of openness is Law 101. The public's right of access to judicial records is a fundamental element of the rule of law. Openness is also Civics 101. The Constitution's first three words make clear that ultimate sovereignty is wielded not by the government, but by the governed. And because we, the people, are not meant to be bystanders, the default expectation is transparency. That what happens in the halls of government happens in public view. Americans cannot keep a watchful eye either in capitals or in courthouses if they are wearing blindfolds. Providing public access to judicial records is the duty and responsibility of the judicial branch. Why is this important? Because accessibility enhances legitimacy, the assurance that things are on the level. Article 3 courts are in
Publicly, some claim those promised solutions did not fully materialize. That's part of why the deposition is viewed as so important. The public wants clarity. They want to know whether statements made under oath align with what was previously communicated through videos, posts, and interviews. If inconsistencies exist between sworn testimony and public messaging, that could raise credibility questions. During a deposition, attorneys can ask detailed, structured questions about timelines, internal communications, and refund decisions. For example, why were some participants reimbursed partially while others were not? What internal discussions guided those decisions? These are precise inquiries that can become uncomfortable when answered under oath. If responses appear vague or inconsistent, that could have implications beyond this single lawsuit. That possibility may help explain the intense effort to seal the deposition. When testimony has broader reputational or legal consequences, the stakes increase significantly. Legal commentators have also analyzed Logan's recent filings and raised concerns about how
independent, and it is particularly because they are independent that the access presumption is so vital. It gives the federal judiciary a measure of accountability, in turn giving the public confidence in the administration of justice. Put simply, protecting the public's right of access is important to maintaining the integrity and legitimacy of an independent judicial branch. And hopefully, more access to judicial records means more trust in judicial officers and more respect for judicial orders. Judicial records belong to the American people. They are public, not private documents. Certainly, some cases involve sensitive information that, if disclosed, could endanger lives or threaten national security. But increasingly, courts are sealing documents in run-of-the-mill cases where parties simply prefer to keep things under wraps. And so this opinion goes on. If you want to read more from it, which I highly recommend, I am linking to a copy of it in the description below. It's very passionate and very clear about how we shouldn't just be allowing parties to mark something as confidential simply because they want to keep it out of the public's eye. And oddly enough, that sounds like exactly what Logan Paul
prior court statements were characterized. According to that breakdown, Logan's team appears to suggest that the judge previously expressed serious concerns about CoffeeZilla's conduct in relation to shared discovery materials. However, when reviewing the judge's written order from September, that specific concern does not seem clearly documented. In other words, the filing may imply that the court signaled a particular worry, but the official written record doesn't strongly reflect that same position. That kind of discrepancy can become problematic. Judges rely heavily on accurate representations of prior rulings. Precision matters enormously in legal argument. The only supporting reference attached to that claim was a brief excerpt from a hearing transcript, and even that excerpt lacked full context. When read carefully, it appears more like routine courtroom discussion rather than a direct reprimand or warning. Yet in the filing lawsuit.
Now that we see the weakness in Logan Paul's arguments here, I want to talk about the pounding on the table part. Specifically, here's where I want to talk about what Logan Paul's lawyers do that I think could end up backfiring. Now, there are actually a couple things that Logan Paul's lawyers do in this reply that the judge might not like, but I really want to focus on one of them. And basically, it looks to me like Paul's lawyers may have twisted the judge's words out of context in order to make their argument.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Let me explain. So remember how in his motion, Logan Paul pointed to something that he says the judge said at some point. Specifically, Paul says, plaintiff has reason to believe that Mr. Findeisen and his counsel have routinely been sharing discovery materials from this case with the class action plaintiff's counsel, something this court expressed concern about when it decided to temporarily stay this case. And
that small portion was presented as if it demonstrated a significant judicial concern. That's where risk enters the equation. Courts expect attorneys to quote and interpret judicial statements with extreme accuracy. Taking a few lines and stretching them beyond their original context can weaken credibility quickly. Judges pay close attention to how their own words are represented. Once credibility begins to erode, rebuilding it can be difficult. From the court's perspective, this may start to look less like a tightly focused legal defense and more like aggressive procedural maneuvering. If a judge perceives that prior rulings are being reframed to support arguments that the record does not fully back up, that perception alone can influence how future motions are evaluated. Ultimately, courts prioritize clarity, accuracy, and strong evidence-based reasoning. If arguments appear overstated or loosely connected to the actual judicial record, that can shape how the entire strategy is viewed moving forward. There's another key detail that legal commentators pointed out when reading the full hearing transcript. In proper context, the judge's concern did not appear to focus on CoffeeZilla
conduct, which, again, constitutes use of discovery materials for purposes other than litigating the claims and defenses in this action. So now when you read this, it sounds like back when the judge decided to temporarily freeze this case back in September, he had this super serious concern specifically about CoffeeZilla sharing information with the class plaintiffs. But if you watched my first video on these arguments in this particular issue, you know that I looked back at the judge's September order staying the case, and I saw that the judge didn't say anything about this in that written order. And so in that video, I said, the only thing that I can really think of is maybe the judge made some kind of a comment at the hearing just before this written order came out. And as it turns out, in the reply, we finally get to see that that's in fact where Logan Paul's lawyers are
acting improperly. Instead, the discussion centered on the overlap between two active lawsuits. Logan is connected to both the defamation case and the CryptoZoo class action. The judge seemed focused on how discovery in one case could potentially impact the other, especially since the class action plaintiffs are not official parties in the defamation lawsuit. That distinction is huge. Logan's team has framed the situation as if the judge was deeply troubled by CoffeeZilla sharing materials. But when you zoom out and read the full exchange, it looks more like the court was thinking about procedural fairness between parallel cases. That's not the same thing as accusing one side of wrongdoing. When courts manage overlapping litigation, they have to be careful. If information flows too freely from one case into another, it can create an uneven playing field. Judges are responsible for preventing that kind of imbalance. It's a structural issue about case management, not a personal attack on either party. If filings blur that distinction and imply something more dramatic than what was actually said, that can weaken an argument. Judges depend on accurate summaries of their own statements. When a filing suggests the court expressed concern about misconduct, but the transcript reflects a broader procedural discussion, that mismatch can matter.
Take a closer look so you can know what I mean. So this hearing transcript that Paul attaches starts out where the judge is talking about CoffeeZilla's earlier request to transfer the case from San Antonio to Austin so that it can be litigated in the same court as the class action case. And there's discussion leading up to this that we can't see, but he basically concludes that he doesn't want to transfer the case over there. So the judge says at the top of this page, "So I'm wondering, I will tell the parties the motion to withdraw, the transfer to withdraw. I'm not transferring this case to Judge Griffin. It would not be fair. I've already had involvement in this case. He's got enough on his plate. But I am considering staying some or all of the proceedings in this case while that case gets rolling. I need to hear from the parties on it. I'm concerned about it. Judicial resources need to be economized. There is the danger of prejudice to both sides. I'm very concerned, even though there's a voluntary agreement by these potential class members to..."
This context also explains why the judge declined to transfer the case to Texas and instead considered whether certain aspects should be paused. From the court's perspective, the real issue appeared to be fairness, while two related lawsuits move forward at the same time. Discovery in one case shouldn't give one side a hidden advantage in another. Some critics argue that Logan may be using the defamation case strategically. They suggest it could provide access to testimony and documents that might later become useful in the CryptoZoo class action. That's a serious claim, and in complex civil litigation, discovery can reveal internal communications, financial data, and sworn statements. Courts have to monitor how that information is used. If material from one case is positioned to influence another, judges must ensure no party gains an unfair strategic edge. That's part of maintaining balance in the system. Logan's past public messaging has also added to the scrutiny. After the CryptoZoo controversy gained traction, he released apology videos acknowledging criticism, thanking CoffeeZilla for raising concerns and promising refunds for affected buyers. At that time, the messaging suggested accountability and corrective action.
I apologize. Step 2, we want to offer a rewards program for players who are disappointed in the status of the game. So essentially, you're going to be able to burn your base egg or your base animal for the mint price, which was 0.1 ETH or the equivalent in BNB. I am personally committing 1,000 ETH to this, which is about $1.3 million. I'm sorry, guys. I apologize for how this has unfolded thus far, and I want people to know that they can trust me and that I'll always take care of the fans and people who support me. And lastly, thank you, CoffeeZilla. You have catalyzed this, and I am very grateful for your work and your investigation, and I mean that. Thank you, bro.
However, some participants later claimed refund offers came with conditions, including agreements limiting what could be discussed publicly. Those claims remain part of the broader conversation surrounding the project. Whether those conditions were appropriate or standard is still debated, but the topic continues to surface in discussions about transparency. The earlier attempt to move the case to San Antonio also drew attention. Venue changes can sometimes influence strategy, whether through jury demographics or procedural timing. The judge ultimately declined that request. Observers have pointed out that when overlapping case dynamics may have worked in his favor previously, there didn't appear to be strong objections. Now, in the defamation case, there's significant resistance to the idea that deposition testimony could circulate in related proceedings. That contrast has fueled debate. From a procedural standpoint, if discovery is lawfully obtained and not covered by a valid confidentiality restriction, it can often be shared with appropriate legal parties in related matters. That's how interconnected litigation sometimes functions. The tension here lies in how each side interprets and applies those rules. Viewed from the outside, this has become a high-stakes strategic battle. CoffeeZilla's legal approach appears focused on preserving access to information and opposing broad ceiling requirements.
Is because, remember, the judge started out here in this hearing transcript talking about CoffeeZilla's motion to transfer the case. If we look back, in that motion, CoffeeZilla made the argument that the whole reason Paul filed this lawsuit was to purposely engage in funny business. Specifically, one reason was to punish CoffeeZilla, and then the other was to get around roadblocks that came up in the class action case and to gather discovery from CoffeeZilla that he could use in the class action case and during a time when the class plaintiffs weren't able to collect any discovery against Paul. So with that in mind, when we look back at this hearing transcript that Logan Paul has attached to his reply, let's home in on one part specifically. The judge says, "I'm concerned with the team on
requests. Logan's team has concentrated on limiting how certain materials are distributed. Every filing shapes the next move. Ultimately, the outcome may depend less on dramatic claims and more on how the judge evaluates procedural fairness, transparency standards, and the credibility of each side's representations. Courts prioritize balance and accuracy over narrative framing, and this connects back to why the judge raised the issue at all. CoffeeZilla previously argued that the defamation lawsuit may have been filed, at least in part, for strategic reasons. The concern isn't about online criticism or personal disputes. It's about whether a separate case could be used to access testimony, documents, and legal positioning that might otherwise be restricted in the class action. Here's where potential imbalance enters the discussion. Through the defamation case, Logan could gain access to depositions, internal records, and litigation strategy. Meanwhile, the class action plaintiffs are not direct participants in this lawsuit. They don't automatically receive the same discovery flow. If one side is able to gather leverage quietly through parallel litigation, courts have to examine that carefully. That appears to be the kind of structural concern the judge was addressing. It wasn't about casual document sharing. It was about whether the legal system itself could unintentionally tilt in favor of one party over others involved in related proceedings. Another detail that stands out is how the hearing transcript was presented in filings. Only a short excerpt was highlighted. When small portions are isolated without full context, interpretations can shift quickly, and in court, context is everything. We still are not seeing the full courtroom exchange. We don't see how opposing counsel responded in that exact moment. We don't see whether the judge clarified those comments later, softened them, or narrowed the scope. And that missing context is not a small detail. It matters in a big way. When only a short portion of a transcript is presented, it can completely change how something sounds. Tone, follow-up questions, and clarifications often shape the real meaning of a judge's comments. Without that full back and forth, it's impossible to know whether the statement being highlighted was a serious concern, a passing observation, or just part of routine courtroom discussion. If the judge had strongly agreed with Logan's framing of the situation, that reasoning likely would have appeared clearly in the written order that followed. Judges usually put their key concerns into formal rulings, but in this case, the written record doesn't clearly reflect the dramatic interpretation being suggested, and that gap raises eyebrows. Lawyers know that quoting a judge comes with responsibility. Courts expect accuracy, they expect context, they expect precision. If a filing presents a small excerpt in a way that stretches its meaning, that can weaken the overall credibility of the argument. Judges pay close attention to how their words are used, and if it appears that prior statements are being reframed too aggressively, that may not land well. At this stage though, one thing stands out above everything else. Logan is fighting hard, very hard, to keep that deposition out of public view. The motions to seal, the repeated procedural arguments, the focus on who can share what and with whom. It all circles back to that same central issue, the deposition. When someone pushes this aggressively to keep sworn testimony private, it naturally fuels speculation. Because here's the simple question people keep asking: if the deposition fully supports his public statements, why not let it speak for itself? Depositions are taken under oath. They are formal. They are recorded. They are detailed. If what was said under oath lines up perfectly with what was said in apology videos, interviews, and social media posts, then transparency would strengthen that consistency. It would close the gap between critics and supporters. But if there are differences, even small ones, those differences can become powerful. In high-profile cases, credibility is everything. Public trust can shift quickly when sworn testimony and public messaging don't align exactly. That's why the stakes feel so high around this one document. There's also the broader issue of transparency in cases involving public figures and large financial projects. When millions of dollars and large audiences are involved, the public interest becomes part of the equation. Supporters want reassurance, critics want answers, and neutral observers want clarity. Sealing the deposition might delay that clarity. It might limit what can be discussed publicly, but it doesn't remove the underlying questions. In fact, sometimes the attempt to seal something can draw more attention to it than if it had simply been released. That's the paradox. At the same time, it's important to remember that courts don't make decisions based on public pressure alone. Judges look at legal standards. They weigh privacy concerns. They evaluate procedural fairness. They assess whether there is concrete, evidence-based justification for sealing records. It's not about online opinions, it's about legal thresholds. So the big question now is how the judge will rule. Will the court determine that the legal arguments meet the high bar required to seal the deposition? Or will transparency win out and the testimony become part of the public record? Whatever happens, this moment feels pivotal because once a deposition is unsealed, it can shape the entire direction of a case. It can influence public perception, it can impact related litigation, and it can redefine how both sides move forward. Logan clearly understands the importance of this decision. That's why the legal fight has been so intense. And CoffeeZilla's team clearly sees the deposition as significant too. Otherwise, they wouldn't be pushing back so firmly against the sealing request. This isn't just about one filing or one procedural motion anymore. It's about credibility, strategy, and how transparency operates when internet fame and large-scale financial ventures collide inside a courtroom. Now, I want to hear from you. Do you think the court will ultimately unseal the deposition and make it public? Or do you believe Logan's team will succeed in keeping it sealed? Drop your thoughts in the comments below. If you've been following this case closely, make sure you like this video, subscribe so you don't miss the next update, share it with someone who's tracking the story, and I'll see you on the next one.